Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Nipasa, and I'm going to be with you for this session today that's lined up, and it'll just take us about an hour. So stay with us because it's going to be a very, very interesting discussion, and you're going to get to know about some very important updates that you wouldn't want to miss out on. So stay with us, friends, and welcome once again to Immigration Talk Show. If you haven't as yet subscribed to our channel, our handle is at Immigration Talk Show. Please go ahead and subscribe now. So, before we head on with today's discussion, I have this disclaimer that I need to read out, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So I hope that you keep that in mind and welcome once again, friends. So today's session is going to be a very interesting one. It's going to be about what's behind the surge in H1B RFEs this cap season. So, yes, it is H1B cap season. And I'm sure that you have a lot of questions, a lot of things or doubts that you really need to clarify. So, please feel free to join us here and ask your questions in the comments wherever you're watching us. We are streaming live right now on YouTube, and you can also check us out on LinkedIn, Facebook, X, and on Instagram. So connect with us and stay in touch with us. And well, with that said, friends, without further ado, please help me welcome our guest for today, none other than Attorney Prashanthi Reddy from the Law Offices of Prashanthi Reddy. Hi, Prashanthi. So good to have you back once again.
Hello.
So, Prashanthi, welcome once again to Immigration Talk Show, and I hope that you're excited. And maybe you could tell us, folks out there who are watching us, what can they expect from this session today?
Hi, Nipasa. Can you hear me?
Yes, I can hear you, Prashanthi.
Okay, great. So, what we're going to be talking about today is the troubling H-1B RFEs that we've been getting.
Mhm.
Some people have been getting with reference to um, requesting them to go for biometrics. Um, and so, we're going to dive into what is the reason for that request. Um, this seems to be on the line of hello.
Yes, Prashanthi, we can. Yes, yes, absolutely, we can hear
Oh,
you.
sorry, I sure, sorry. So this seems
No
to be
problem.
on the line of the CVIS revocations. On the same line, they're sending out RFEs, so we're going to be talking about that. How to respond to such RFEs, what these RFEs mean, etc., etc. So, AILA has been receiving multiple reports of this new RFE trend on all employment-based cases on H's, I-140s, and the RFE basically states that we have encountered potentially adverse information related to the beneficiary, and it says that to continue processing your application, a petition, we require an updated address for the beneficiary so that we may collect biometrics data. So that's what the RFE is saying, and so we're going to delve into that a little bit as to what that means and how to respond to those RFEs.
Correct, correct. And it's very shocking because earlier nobody used to ask for biometrics, especially not from applicants. And so, friends out there, stay with us because it's going to be a very important discussion and new updates that you don't want to miss out on. And for those of you who know Prashanthi Reddy, she has been, practicing immigration law for almost 3 decades now. So definitely go check her out. And if you want to have a one-on-one consultation about your case, certainly reach out to her. And her number is 212-354-1010. You can also email Attorney Prashanthi Reddy at prashanthi@reddyesq.com and go check out www.reddyesq.com to get to know more about Attorney Prashanthi Reddy and the law offices of Prashanthi Reddy. So, folks, I hope you're ready for today's discussion. And just like I and Prashanthi, we both are super ready. So, Prashanthi, I think we should not wait any further. And I have this first question. We're hearing, that RFEs are being issued more frequently this season. And this was also predicted, before a few months back also. So, what's driving this spike, if you can tell us? And is this a part of a broader policy shift?
Yeah, absolutely, it is. The present administration is um, stricter with reference to immigration. As per Trump's several executive orders, including the alien invasion order, um, you know, there is more vetting now. As per the executive order, they're doing more vetting. So we can expect more requests for further evidence. Also, the recent regulation could also be a reason for more RFEs, because before the new H-1B regulation, especially for consulting companies, and this is mostly for IT consulting companies, USCIS was not asking for client letters and purchase orders, contracts, etc. They were not asking for proof of work. That, of course, can be asked from anyone, but for consulting companies, it's especially asked for, in very strong terms. So you have to show that you have a bona fide job for the employee, and before, under the previous law, even if you didn't have, especially because of the lawsuit that IT Services Cessna, even if after the lawsuit, even if you did not show a bona fide uh, job, they were still approving those H1s. They were not sending RFEs on that basis. But now, under the new H1B regulation, since it's in the regulation itself, they are um, asking for proof that as of the date of filing the H1B, you have proof of job availability. So it cannot be speculative work. If you are a regular company, then you just have to show that you're in a certain business, you need to hire an additional employee, and you need to justify why you need that additional employee. Maybe you can say that you have additional work, you can show new contracts, you can show uptick in business, or maybe you have a new need or a new type of business that you're starting, a new branch of business that you're starting, and you need that particular employee to help with that new branch of business. And if it's, as I said, an IT consulting company, then you have to show that you have and if that person is going to be placed at an end client site, then you really have to show the contract with the end client to show that you have business requirement to hire that particular individual. Now, that's why I guess USCIS is sending out RFEs. If you don't show that, they're also sending out RFEs with reference to specialty occupation, especially if you have a job that does not seem to be directly related to your degree, or if the job does not seem to require a bachelor's degree in a specific field. That's when they send out specialty occupation RFEs. The other type of uptake of RFEs that we're expecting is maintenance of status RFEs. As per again the new H1B regulation, the USCIS is supposed to ask for status documents in an extension or a transfer case, and that could lead to RFEs as well. They could be asking for more maintenance of status RFEs, where they're asking for proof that you maintained status during your previous H1B term. And when they ask for that, they're asking for pay stubs, they're asking for W-2s, they're asking for proof of your work product, they're asking for letters of employment, etc., etc. So all these documents, so we can expect that kind of RFE also. And as I said, last but not the least, we are seeing a troubling uptake of RFEs where they're asking for the beneficiary's current and updated residential address And they're saying that there's some adverse information that they have encountered. They're, of course, not saying what the adverse information is. And they're asking for the present address. And, and that's a little troubling because this seems to mirror the CVIS termination emails that they're getting for students. Information could be adverse with reference to the beneficiary. Maybe they were charged with something. There's fingerprints were taken at some point, and so we have to be careful while responding to those RFEs and what information we give and what strategies we follow.
Right, Prashanthi. I mean, you've already covered almost what I wanted to ask next. So, regarding these unusual requests, if you talk about whether it's biometrics or the address changes, addresses, uh, why do you think they have these unusual requests this time? The reason behind,
So
if you have anything in mind.
this is again based on uh, the president's executive order, with which is asking USCIS to conduct extreme vetting, and also with reference to recent CVIS terminations, where they're terminating out of students CVIS. Maybe this is going to also affecting all non-immigrants other than just students. Now maybe they're doing the same thing for all other non-immigrants. So as I said, AILA has received multiple reports of a new RFE trend on employment-based cases. This is not just H1s but also I-140s, and they're basically saying that they've encountered potentially adverse information related to the beneficiary, and they're not really saying what the adverse information is. And they're saying that to continue the processing of the case, they need updated address so that they may collect biometrics data. So they might ask the beneficiaries to come in for a biometrics appointment. And if they have some adverse information, which we don't know what that is, when they do come in for biometrics, um, to give biometrics, it's possible that they can detain them or, most probably detain them and start removal proceedings against them. We are thinking the adverse information could be that they've been arrested at some point or they were charged with, and we know with reference to these cases, they don't care whether they were guilty or innocent or whether their charges were dropped. It's again, they're mining the information from a source and they're just sending out CVIS termination emails and maybe these RFEs blindly for anybody who's, in that database.
Right.
So, I mean, AILA has been, of course, contacted USCIS and they're waiting for more information from them. But as I said, it could be like a data mining operation. Um, and it could be some kind of a prior incident of law enforcement or minor traffic violation, which could have been dropped or dismissed, or maybe they were convicted of it. But these were all petty offenses, so I think this could be one of those instances, or many of those instances, where this can be showing up even with other non-immigrant petitions. So it's very important. That's why I decided to have a separate segment on this. With reference to what can be done, I think I think it not just blindly give them the address, but it's possible that you might want to cite a regulation where USCIS is supposed to specifically disclose what that adverse information is, and based on that, um, you know, that particular law, then I mean, cite that particular law and hopefully get more information from USCIS as to what that adverse information is. It's important, I
Yes.
think, to find out what it is before giving them information. So there is a law which, 8 CFR law, under which you can ask for this information to be disclosed before you give them any further information. So that could be one way of doing it. Um, and I think that's what I suggest that be done. That's eight. That section is 8 CFR 103.2 B16I. So this is the law under which you can ask for further information as to what information USCIS has that is um, as a result of which they're sending this RFE. So we recommend that you do that. It's possible, as I said, that they could be upon arriving for their appointment. So we don't suggest that you just follow and show up for an appointment. That could
Yes.
result in problems for the beneficiary.
Right. Right. Thank you so much, Prashanti, for taking that up. And, I would also like to say hello to Samantha, Robert. Thank you so much for joining us with your questions here on YouTube. We are going to take them up. Just stay with us for now. So, also, Prashanti, we do have some more questions. And, I wanted to also know, since there has been all this increased scrutiny, and is it only affecting the first time H1B applicants, or even renewals and transfers are being impacted too?
With reference to, I think the other RFEs, I think cap cases usually get more RFEs than extensions and amendments because as per the H1B regulation, the new H1B regulation, there is a deference policy, which means that if the H1 was previously approved and if no facts have changed, then um, they should give importance to the previously approved case, and they should not be asking the same questions over and over again. So they on extensions based on this about extensions and maybe amendments, there should be less RFEs if nothing has changed.
Okay.
But with reference to new cases, we definitely do see those more RFEs at any time. But with reference to this new RFE, which is asking the beneficiary to go for biometrics, I think this could be with reference to any beneficiary that has now that has had any run-in with law enforcement, and if they are filing, whether it be an extension, an I-140, a transfer amendment, I think they might get these kind of RFEs. Yeah, the request for biometrics to come in for biometrics.
Okay. All right, Prashanti, thank you so much. Well, now if you can walk us through the typical RFE received, this cap season maybe, and how does it differ from RFEs in the previous years?
So as I mentioned, I think already, I'll go through that again. Because of the H1B new regulations, new H1B regulations, there are certain RFEs that we can expect this year. One is the proof that you have specialty occupation work available for the beneficiary. And as I was saying, proof of that is proof that your business actually requires the employee that you're filing the H1 for. Can you hear me, Nipasa?
Yes, Prashanti, I can hear you.
Okay, so proof that you actually need the person, that you have enough work for the person that you're hiring, enough specialty occupation work. If that's in an end client, if that's in a, consulting scenario, then you have to show proof of end client contract. If it is in a general scenario with other businesses, you have to show that you have enough business to hire that particular person. For example, if you are, say, a healthcare company and you are seeking to hire a software developer, you have to justify why a healthcare company requires a full-time software developer. So you have to give an explanation. So that's one kind of RFE that you might receive. The other one is the maintenance of status RFE, as I was mentioning earlier. The new H1B regs also says that you have to show maintenance of status when you're filing your H1B petition. So they can ask for proof such as pay stubs that you're being paid the prevailing wage. They can ask for W-2s. They can ask for information. Basically, the lot of RFEs I'm seeing, especially if you're not working as per your LCA work location, if your address is different from your LCA work location, then they're asking for maintenance of status. They're sending maintenance of status RFEs, and they're pointing out that your LCA says that your work location is XYZ, but you're actually residing in a different state. Um, and your pay stub shows a different address. So, are you actually
Mhm.
working at as per the work location in your LCA? So, that's a common RFE that we're seeing. Also, in order to show that you're maintaining status and you've actually worked and you're not just getting paid a salary without working, they're asking for proof of the work. They're asking for work product. They're asking
Yeah.
for any offer letters, employment letters, any letters that you receive from your employer showing that you've done a good job, or if you've received a bonus, if you've received an increment in salary. They're asking for those kind of letters as examples of proof of work. They're also asking for uh, work schedules as to what work you do and what schedule you follow, and they're also asking for from the employer that they show that they have reviewed your work. So review documents. So these are a few documents that you can show and keep ready, and maybe submit initially when you're filing for H1 extensions or transfers.
Okay. Okay, that's very interesting. And thank you so much, Prashanti, for taking that up. Well, definitely there has been new updates, and with that also new RFEs, which are much different if compared to the previous years. So, friends, be ready, and if you need to consult with an immigration attorney, you should, in fact, so that your whole process is a little more smoother and there's more clarity within you, and so that you can remove all the confusion and go ahead with confidence in the direction that you are supposed to. So, all the best. Make sure that you have all your documents right and you do notify all the officers about your change of address or any updates with your address, at least, and also USCIS for that matter. So, also, Prashanti, if you need, I mean, if you also want to contact Attorney Prashanthi Reddy, do call her up or email her or go visit her website. You'll get to know more about her. And you can call her on the number 212-354-1010 or email Prashanti at reddyesq.com. So I think, Prashanti, we should take up some of our comments now, and let's take up Samantha's first. Once again, Samantha, thank you so much for participating. And also, friends, you can join us in a conversation by calling us to ask your questions, by the way, let me tell you. And that you can do by calling us on 425-436-6335, and the access code is 988-888. Today's discussion, friends, is very interesting and important. It's about what's behind the surge in H1B RFEs this cap season. So make sure that you also share our content with your family or folks who would benefit for sure. All right, so Samantha's asking, Prashanti, considering the tightening of H1B visa criteria, what are the chances that an RFE will turn into a denial? And how can applicants improve their chances of getting approval after receiving an RFE?
So yes, once you get an RFE, there is much higher chances of a denial. So it's always important that you submit a perfect application if you can. So since you know, I mean, so that's why the attorney comes in, or a person whoever is filing it has to have intimate knowledge of the law and the new regulation. Since we know what to expect, what you need to do really is submit all documentation that you can with reference to what the new regulation is. So, since we know maintenance of status is a thing, you submit all the documentation to show that you maintain status. Since we know that there is a chance that you'll get a specialty occupation RFE, it's important that you uh, mention the job description very clearly in your petitioner letter, and make sure that the job description is complex enough to require a bachelor's degree in a specific field. Make sure the job title that you're using, as well as the job description, requires, as per industry standards, a bachelor's degree in a specific field. So, job titles, job duties, explanation of the job duties, giving examples on a day to day basis what the beneficiary will do, and why a bachelor's degree in computer science, for example, is so important, explaining the complexities of the job. All these can improve your chances of getting an approval, and submitting proper documentation with reference to status is also important. if you do that the first time around, you may not get an RFE because some RFEs are really predictable, and companies sometimes file skeleton petitions, and you can say like 90% of the time that they'll get an RFE. Especially in those instances, it's best to avoid RFEs because once you get to submit much more information and documentation, and then of course the chances of denial are much higher.
Okay, okay. So, all the best, Samantha. Thank you so much for participating with your question. If you have more questions, feel free to keep commenting. Now, let's take up Robert's comment saying if a company receives an RFE regarding the wage level for an H1B employee, does this indicate that USCIS has doubts about whether the salary meets the prevailing wage for that position, or is there another underlying concern?
Uh, so if the RFE is regarding which wage level you're using, that is not about um, whether the beneficiary meets the prevailing wage standards or not. It's more about whether you're using the right wage level or not. So if the person is an experienced person and the job requires a few years of experience, and it's not a position that is fresh out of school, entry level position, and you use level 1 for that kind of position, then you will get an RFE with reference to the wage level that you're using, and they might say that this position show us that it's an entry level position, show us what the requirements for the position were. So if it's a bachelor's plus under 2 years of experience, it could still be an entry level position, or even if it's a master's level. And um, even if skill sets are being used, it could still be an entry level position. But if more than 2 years of experience is required for the position as per your advertisement, and you're supposed to place an advertisement on your website or somewhere else before you file the H1. So you have to show them that advertisement and show them what the requirement was. And then there is a table that employers are supposed to use when they are calculating the wage level. And so you have to show them that table as well and how you calculated the wage level to be level 1. For example, we generally suggest that all employers use level 2 or more. But if they're fresh graduates, like uh, people on OPT or CPT, or people just out of school, then I think using level 1 is still okay. And we have not seen RFEs simply because we've used level 1 wages. There used to be RFEs under Trump's previous administration, in his previous when he was president, there were RFEs, I remember, level 1 wages, but we are not seeing that anymore. So as long as you're able to justify what the wage level is, you should be able to respond to that RFE successfully.
Welcome back, everyone, from a short break here on Immigration Talk Show. I'm Nipasa, your host, and I hope you're having a wonderful session here on Immigration Talk Show. So, yes, we have none other than our guest for today, Attorney Prashanthi Reddy from the law offices of Prashanthi Reddy, and we have been discussing on, what's behind the surge in H1B RFEs this cap season, and we have been covering a lot of important points. I hope that you have been keeping note, and even if not, Please feel free to go back and watch, whatever we've discussed so far. The latest updates are, they have been also asking for biometrics and address updates. So I hope that you have all of your documents ready, including your biometrics. And also, we have been taking up some questions from our audience, and that was Robert's answer. Thank you so much, Robert, for your questions once again. And now we do have Rahul with another question here on YouTube. Hi, Rahul. Thank you so much for joining us. Feel free to join us on call as well. And the number is up there on the screen, friends. Anybody out there, the lines are open for you to call in. So Rahul is asking, when a petitioner receives an RFE questioning whether the role truly requires a bachelor's degree or higher, what specific documentation or evidence can be presented to counter these doubts? Are job titles and duties alone sufficient, or do we need additional support?
Truly requires a bachelor's degree with a role. Okay, so job duties, explaining the complexity of the job, breaking it down in a table to show the courses that you took in college and how they're related directly to each job duty is one way of doing it, and you should do that as well. But in addition to that, you also have to show, possibly you could show that it's industry standard for the job to require a bachelor's degree in a specific field. So also, if your employer has hired people with a bachelor's degree in a specific field for the same job before, then the employer can show the W-2s and the degree copies of the employees that he's hired before for the same role. And then industry standard also means that other employers have done the same. So you could get letters from other employers as well that are of similar size to your employer, showing in a letter stating that they have looked at the job description and they have also hired people with a bachelor's degree in that particular major for that particular position in the past, or they always do that in the past. Also, you can go through job search websites like Dice or Monster, and pull and print out job descriptions and job requirements with reference to your particular job, and show that a bachelor's degree is required again in a particular field for that job. And last but not the least, you can also go to the Occupational Outlook Handbook, which is online. So just go to Occupational Outlook Handbook on Google and you'll find it, and then type in your job title, and you should most job titles are mentioned in there, not all, but the job title, if it is mentioned, then it will be the educational requirement will be mentioned very specifically. And if the OH requires a bachelor's degree in a specific field, then that's proof enough that it's a specialty occupation, because the USCIS usually goes to that publication written by the Department of Labor when they see whether a position is a specialty occupation or not.
Correct.
So these are a few ways that you can justify. Another additional way to justify is also getting a specialty occupation, getting a expert opinion letter on whether your position is a specialty occupation or not, by sending your job description to an evaluator or a professor, and they can give an expert opinion letter as to when, if they think, of course it has to be a professor in that particular field, but they can look at it and give a letter as to whether they think that the job requires a bachelor's degree or not.
Okay. Well, there you go, Rahul. Thank you so much for your question, and thank you, Prashanthi, for taking that up. So, all the best, Rahul. We have Radhe Krishna saying just F1 visa. I don't know what is the question here, Radhe. I hope that you have a question and can give it out to us soon. So please ask a question or join us for the discussion on the call. And you can call us on this number 425-436-6335, and the access code is 988-888. That said, Rahul, and then we also had Robert and Samantha. I hope that you resonated with the answers that you got from Attorney Prashanthi Reddy. Don't forget to subscribe to our channel if you haven't as yet already. Our handle is at Immigration Talk Show, And also check us out on LinkedIn, Facebook, X, and on Instagram. And yes, Prashanti, we do have more questions. So um, let's go. I mean, control. If you can also display some of our questions from our Facebook and YouTube, maybe it'll be great. But meanwhile, Prashanti, if you can also tell us, how should applicants respond if they receive an RFE with unclear or broad requests, especially regarding potentially adverse information.
Right. We're back to that RFE again, where they've been asking
Yes.
for them to come in for biometrics because there's some adverse information. As I said, if they're not giving you that information, you have every right to ask for what the adverse information is, because USCIS, as per again 8 CFR 103.2, is supposed to disclose the adverse information that they have, so that and give you an opportunity to refute it or to uh, explain it. For example, if you say were arrested but you were never charged and you were let go, you're innocent. You've not been convicted or even charged of anything, so you can give them that response because they may not know that. So the USCIS has to give you an opportunity to look at the adverse information that they have, and for you to respond to it and give an explanation with reference to whatever adverse information they have. So you can, I think, a good response to that kind of RFE is asking for what adverse information they have and citing the law under which they are asking for that information. It's possible, of course, that if you don't respond to an RFE and the information requested in it, and you respond by asking a question, they might deny the H-1B petition. Then, of course, you'll have to file an appeal, or you might have to go to federal court uh, in order to resolve it. And if there are many cases like this, I'm sure that will be another issue before the federal court, in addition to the, tens and at least hundreds of other lawsuits that have been filed so far.
Right, right. Thank you so much, Prashanti. And I hope that folks out there are ready for this. This changes. I know it's sometimes and most of the time it's surprising, especially lately, every day with new changes. But it's very important to be on your toes, friends. Collect yourself and be ready for anything and everything, including the biometrics that you might have to provide anytime they ask for it. So, all the best. Keep your documents updated. Keep that in mind and do your research. Keep yourself updated. Stay informed, especially by subscribing to our channel. Our handle is at Immigration Talk Show. Don't miss out on any of the latest US immigration updates. All right. So, Prashanti, I think let's take up some of our questions from Facebook now. So, yes, Control, if you can display them, please. This first one is asking, this is from Hamad. My EB3 perm apply 27th December 2023. Please tell me approval time approximately.
It should have been approved by now, because the perm usually takes a year and maximum a year and a half to get approved. So, especially if there's an audit, it might take longer. Otherwise, it takes about 10 months. Um, so maybe there was an audit and there is a delay in your case. So you should keep, or your employer should keep checking on the flag portal to see if there are any updates. But it's been almost a year and a half, so you should be getting something very quickly, very soon. Usually takes 8 to 10 months, but as I said, if there's an audit, it could take longer. Sometimes up to 2 years.
Okay. All the best, Hamad. I hope that you do get it soon. And now let's take up the next one. Control if you can zoom in. Yes. So this is from Masashi. Hello all. I filed my I-140 and concurrently, sorry, let me just say that once again. Hello all. I filed my I-140 and concurrently my and my wife's I-485, I-131, I-765 all at the same time, putting them together in one packet. My I-140 was just recently approved. Are my wife's are my and my wife's I-485 processed together or these separately processed? That is the I-140 is about the company where I work. My wife is just a dependent, doesn't need to get I-140 for her. And my I-765 was also approved, and USCIS sent me an EAD card. But my wife's one hasn't been yet. So he hasn't received that yet. Looking at her My USCIS account page, estimated processing time of the I-765 is 38 months. Stupidly long, he says. I wonder whether my wife's case are reviewed and processed separately, even though she is my dependent. Does anyone here experience similar situation?
So, yeah, that is definitely an issue. Your wife's petition should be processed along with yours. But if you have just filed it, and so it's not necessary that you should both get the EAD at the same time. I wouldn't really pay attention to the 38 months because that's a long period of time. I don't think it'll take that long. But it could be that your wife's EAD is also, will get approved soon. So there's no reason to think that it should take 38 months. Um,
Mhm.
and what is the question? Will it be a, well, it's processed together. That seems to be the question. Yeah, the wife's and your 485 is processed together. They keep the package together because she's your dependent. They don't have a separate file for her. They keep both files together. That's what they always do at USCIS. So if there's an RFE, everybody gets an RFE at the same time. But you may not necessarily get EADs at the same time, an I-765. So you have to wait. It's not necessary that it will take 38 months. She should get it in 6 to 8 months or at least 10 months. Uh, and I think that's the question he has.
Yes, I think so.
Yeah,
Yes.
yeah,
He wanted to know whether they are going to be reviewed separately and processed
right,
separately.
right. And they're not.
Thank you, Prashanti, for
They're kept together. Yeah, they're kept together.
they kept together. Okay, okay. So let's be a little more patient,
Also,
Masashi. That's all
I
I can
think
say. Yeah,
he's also asking my I-140 was recently approved. Are my wife's me and my wife's 485 processed together or are they separately? Oh, that's again the same question. He's asked it
same
twice. So
question,
yeah,
right?
I think we're good. Yeah.
So, Mashashi, I hope you receive for your wife as well as soon as possible. Just be a little more patient. Thank you so much for your question. Now, let's go on to this one. This is from an anonymous member. Any idea how long it's taking to start tracking the visa status? I'm getting your search did not return any data on visa status check site. I have verified all my information multiple times. I dropped off my passport for Dropbox on April 16th at Hyderabad for Chennai location.
I think you're being overly anxious about your visa application. It's possible that it'll take a month or two, even for Dropbox. It's possible that you may not have a Dropbox, but you may be called in for an actual interview. So anything is possible. I think you need to wait some more time before you reach out. At least a month or two before you reach out to the Department of State for an update, or can expect any update.
Okay. Yes, I mean, it's just been a week. So, anonymous member, a little more patience, please. Let's do this. And now we have this next one, also from an anonymous member. Hello, I have a job in USA. I traveled to India to have my passport stamped with H1B, first time stamping. I completed the OFC at Mumbai VAC and they have put a stamp on the DS-160 confirmation page. After that, I realized some information in my DS-160 is incorrect. My interview is next week. What are my options here? Thanks.
It depends on what information is incorrect. When you go for your visa appointment, you can always speak to the visa officer and get the DS-160 corrected if it's something that is significant and you want it corrected.
All right. All right. So I think this goes out to folks out there who know that they made a sort of a mistake in their DS 160. And I think when you have your interview, make it a point that you point it out and try to correct it as soon as possible, just to avoid any sort of misrepresentation later.
Correct.
So thank you, Prashanti. Yes, thank you for taking that up. And now let's go on for the next question. Control, if you can display, please. My H-1B stamping done on September 2024. Due to personal reasons, I have not traveled. Will there be a problem if I travel on June or July, or do I have to go for a transfer? Please pour your suggestions. Thank you.
I'm not sure why he wants to file a transfer. What is the background before, with reference to
Right.
that? Is there something that he's worried about with the present employer? Uh, H1B stamping is in 2024 due to I have not traveled. I mean, so basically, what he's saying, I think, is that he's presently in India and the visa got approved in 2024. I think I understand, and it's been more than a year, almost a year and a half since the visa was approved, but he never traveled on that visa. So yes, it is a long duration since the visa was approved. So if you're traveling now, very important that you show an updated employment letter showing that there is an updated and current job offer. Carry with you the contracts, work order, MSA, um, which is again updated. Make sure that the work location in all those documents matches with the work location in your LCA. And they might ask you questions as to why you didn't travel all that time. Maybe you have a letter from your employer stating why you didn't travel and why you're traveling now. So these are all the things that you need to carry with you.
Right, right. Thank you, Prashanti, for taking that up. And all the best to anonymous member. Let's go on to this next question. Also from another anonymous member asking, we are currently in the USA on L1 visas that expire at the end of the year. I started a delivery business last year and am considering changing to an E2 visa. I'm planning to purchase a vehicle and rent a commercial space for a year. Is it mandatory to hire an employee immediately for the E2 visa application in this situation? What are the advantages and disadvantages of pursuing an E2 visa for my delivery business? Will it be worth having a vehicle and business place? I would really appreciate your thoughts and suggestions. Thank you.
So I would say don't be careful with the E2. You seem to think that it's easy to get an E2 visa, and if you just um, work for yourself and buy a vehicle, it'll be possible to get an E2 visa. An E2 visa is not given that easily. You have to show that you have invested. I mean, there's no amount of money that has to be invented, but it has to be a reasonable amount of money that has to be invested. There has to be, you have to show that there is no marginality issue in your company, meaning that your profits are not marginal. Your profit should be enough to sustain you, your business, and any employees that you have. So it's possible that a small business um, not making much profits, it may not get approved if it's too small a business. So be careful about that, the marginality issue there. Um, and you have to show that whatever money you invested, you have to show clearly the path of investment and you have to show exactly what it was used for. So the disadvantage of an E2 is unlike an L1, you don't fall into the EB1A category. Uh, you have to file a regular labor cert in EB2 or EB3, which might be difficult to file in your case if you're self-employed because you can't file a perm for yourself. So that is the biggest disadvantage I see for you in the E2. Um, will it be worth having a vehicle in business place? I mean, without that, you can't file an E2. And even if you do all that, your E2 might get denied. So you have to make sure you have a strong case and speak to a immigration attorney before you decide to take up this venture.
Calling from India.
Okay, okay. Hi, Prashanthi. We do have a caller actually, and I just want to put him up. Vasant from India calling us, and he has a question to ask. So, Vasant, please go ahead.
Yeah. Hi, Prashanthi. Yeah, good. Like, thank you for like being online and asking and responding to your questions. Okay, so I have one question. So my wife has a H1B which got stamped during 2023. Okay, she has not traveled to US because of her maternity, and now uh, her employer, right? So her employer has terminated her job in India. Okay, but the H1B visa, which was there, which is a subsidiary, which is presented in US. Now, her H1B visa validity is still available until September end. Okay. Can she travel with the I-797 to US and to get a H1B transfer?
You can definitely use the visa, but you need to apply for an I-797 because, as per what you're telling me, the employer that filed the I-797 and got it approved doesn't have a job for you anymore. So you cannot travel with that I-797. You have to file for a new employer I-797. So get a new job, but you can definitely use the existing visa, but not the existing I-797.
Like existing visa, she can travel, but she cannot go and get registered for assistant, right?
You cannot use the existing I-797 approval to travel because that I-797 approval is linked to your employer and the employer should still have a job offer for you. If that employer does not have a job offer for your spouse, then you have to file for a new H1, get a new approval, new I-797, and travel with the new I-797 and the old visa.
Okay.
Okay. Fine. And can she travel with that visa to US?
As I said, yes, you can use the old visa, but you need a new I-797.
Okay.
Okay?
All
Fine.
right.
So in that case, she is eligible for the H1B cap exams, right?
Yes, she should be, but the definition of H-1B cap exempt keeps changing, and under the new administration, they've become very strict. So I would definitely, until before they change it, I have seen some instances where they are not accepting such cases as H-1B cap exempt, but I would still file it as soon as possible because they might still approve it for cap exempt.
Okay.
Okay. Okay. Fine. Thank you. Thank you, Prashanthi. Thank you so much.
You're
Thank you
welcome.
so much, Vasant, for joining us.
Yeah. Yeah. Thank you.
Thank,
Thank you.
thank you so much, Prashanti, also for taking that up for Vasant. And there we go, friends. Thank you, Vasant, once again. I hope that you got your answer and all the best with your new I-797. So let's go on now and take up more questions if we have some more. Thank you, Prashanti, for being such a sport. And friends out there, you can also join us just like Vasant did just now. All you have to do is call us on this number 425-436-6335, and the access code is 988-888. And Vasant, please don't forget to subscribe to our channel if you haven't as yet, and also share our content with your friends and folks who would benefit. So, yes, let's take this question now. Currently, I am employed with employer A. Can I initiate an H-1B transfer to a new employer B with the same client and at the same time file for another transfer to employer C with a different client?
Yes, you can. Uh, yeah, you can, and then you can decide which company that you want to go with, as long as you're in status. Before you file any of the transfers, you can file multiple petitions. I mean, there was something called the last action rule, but I think USCIS doesn't care about that anymore. I mean, the last action rule was, whatever case you filed last, that would be your status. But I think with reference to transfers, I don't think USCIS applies that last action rule. So you could potentially file a transfer to any employer and file two transfers and decide which one you want to use.
Okay. Thank you, Prashanti, for taking that up. And it's interesting. Felt like I was reading an algebra question first. But yes, there you go. And now let's go on to our. Okay, we are done with all our questions for from the audience. But let's take up Satish's. Hi, Satish. Thank you for joining us here on YouTube. So Satish is asking H1B picked through current employer. Petition will be filed soon. H1B start date is October 1st. I'm on OPT now and working as a contractor. Client wants to convert me to FTE in June. Can I join them while staying with the H1B sponsor? When is it safe for the client to file a transfer?
You have to hold your horses, Satish, because you have to first file the H1B. It has to get approved. You have to start working on that H1, get a pay stub, and then move to the client. If you move to the client now, then then are you going to move back to your employer after October 1st? Because you have to. So make up your mind as to what you want to do. I would suggest that you stick with your sponsor, get a few pay stubs, and then file a transfer to your full time employer.
Okay. Thank you so much for taking that up, Prashanti, for Satish. And Satish, thank you for your question, for participating. And I think with that, we have definitely covered most of our audience questions. So, Prashanti, also, I wanted to know before we leave, um, what should H1B hopefuls and current visa holders do right now to prepare themselves for, tighter scrutiny or even policy changes that are happening every day and ahead?
Prepare properly. Be aware of what the law is. Read the new H-1B regulation. Use an attorney or someone who's an expert at filing H-1B petitions. And make sure you don't file skeleton petitions and you file, well-rounded, complete petitions with all the documents included, and do your homework properly. Choose the right job title, write your job description well. These are all important for a successful H-1B petition.
Right. Thank you so much, Prashanti. It was great, really, having you today. And, we had important points of discussion. These are the latest, and people have heard of this just probably since yesterday. And they're kind of worried what is going to happen. But I think there's nothing much. Let's just, should they be worried, Prashanti? I think it's just another step to be more prepared, right?
I'm not worried about the new H-1B regulation. I think, as long as it is followed in the spirit that it was written, I'm not worried about it. But if the present administration uses the H-1B regulation in a way that it was not supposed to be used, and asks, for a lot of documentation, make it impossible for employers to provide that documentation, then it'll be a problem. But I haven't seen that yet. But I am concerned about the new H-1B RFEs where they're asking for biometrics and they're talking about, adverse information and stuff like that. Those kind of RFEs I'm worried about because I'm worried that
Mm.
it'll be another CVIS termination type of situation. And there could be a lot of them potentially, as we've seen that there are a lot with the in the student cases as well. So we have to wait and see how that plays out, and just hope that it doesn't. Our worst worries don't come true, and everything goes smoothly.
Yes, I think so also. And I think it's better to think positive things, manifest good things, and be prepared for anything. So, all the best, friends. And thank you so much, Prashanti. Had such a great session and insightful one with so much good and important information. So, thank you once again. Always great
Thank
having
you.
you.
Thank you, Nipasa. A pleasure, and I'll see you next week.
See you next week. Have a great day, Prashanti. And folks out there, also, thank you so much for joining us. And if you do want to have a one on one consultation with Attorney Prashanti Reddy or contact her for any question that you have, Please feel free to call her up on her number. Her number is 212-354-1010. And make sure when you contact her, tell her that you saw her through at Immigration Talk Show, our handle, and let her know so that she'll be more happy to help you out. So her email address where you can also write to her is prashanthi at reddyesq.com, and go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy and the law offices of Prashanthi Reddy. That's it, friends. Thank you so much once again. I hope that you don't forget to subscribe to our channel. And Satish, thank you also so much. He says thank you. So thank you for joining us, all of you. Please make sure that you subscribe to our channel and also share with your friends and folks who would benefit with our content. These are the latest updates on US immigration that you don't want to miss out on. And yes, you can always keep checking out the webinars we have, because there's so much important information that you don't want to miss out on. And that said, you can also contact me or write to me. My email address is nipa@staffingly.com, or I do have a WhatsApp number where you can also write to me or call me up. My number is 408-335-6444. So this is it for now. But stay tuned on Immigration Talk Show, because we have another webinar lined up at 2 p.m. Eastern Time with Attorney Justin Rivera from Boston Immigration Litigation. And it's going to be another insightful session. So don't miss out. For now, this is it. Bye bye.